Hello, everyone. Welcome to Chapter 3, Legal, Ethical, and Professional Issues in Information Security. By the end of this chapter, you should be able to describe the functions of and relations among laws, regulations, and professional organizations in information security. We will focus more along the lines of US laws and regulations, as well as a bit of international communities, laws, and regulations that it pertains to technology, cybercrime, information security, privacy, and pretty much everything technology. Also, by the end of this chapter, we should be able to explain the difference between laws and ethics, as well as policies. We should be able to identify major national laws that affect the practice of information security within US and as well as international organizations. We should also be able to discuss the role of privacy as it applies to laws and ethics in information security. This includes things like educational privacy, data privacy, children protections, as well as HIPAA and all those interesting privacy laws currently in place. So, it is the responsibility of every information security professional to understand the legal and ethical responsibilities of their organizations, as well as the community, be it the state, local, and federal level. They should also be able to minimize and reduce risk to an acceptable level within the organization, which means every security professional should be able to understand the legal landscape, at least stay current with laws and regulations, as well as update their internal organization policies to reflect current laws and regulations, and also to watch for new and emerging issues. An example of this could be by updating their internal policies because GDPR has added some requirement for additional controls towards privacy. So it is the responsibility of every security professional to be able to understand what GDPR is meant for as well as how it applies to their organizations. Now that we're talking about organizations as well as laws and policies within organizations, we are going to look into the difference between policy and law. So policies are managerial directives that pretty much specify acceptable and unacceptable employee behavior in the workplace. And it is not only limited to just employee. It could be, well, not limited to full staff employee. It could also be contractors as well as anyone who does business dealings with that organization. There are certain criteria for policy enforcement. One is dissemination, meaning every single employee that is covered under that policy should have access to that policy. Every employee as well should be able to read and understand the policy. They should comprehend the policy, meaning words and terminologies that are not common to that organization or might be difficult for the employees to understand should not be a part of the policy document. Compliance. Every employee should somehow accept and agree to that policy. Meaning, if an organization drops a policy, they are they should definitely find a way to ensure that each single employee or each single person that the policy covers accepts the policy and agrees to all the conditions within the policy. It could be during onboarding process where they had to sign that they agree to company XYZ policies so long as they're employed with the company. It could be electronic, it could be different means. Uniform enforcement. This means that the organization should employ, well, shall enforce the policy uniform along the employees and everybody. An example is there shouldn't be one policy for a certain type of employee and another for a different employee. Employee A and B, if they are within the same department, have the same type of duties, and are pretty much executing the same type of jobs, should be under the same type of policy. This is to avoid discrimination at workplaces and pretty much to avoid legal actions and ensure uniformity among employees and enforcement of the policy. Laws, however, are a bit different with policies because laws are rules that mandate or prohibit certain behavior and are enforced by the state. The state meaning could be the federal, state, or local level, could be in the form of a constitution, could be a regulatory body like legislative body passing laws. Those all fall under the law, and it is not only limited to a certain organization, it's limited to a jurisdictional boundary along the lines of federal, state, and local levels. We have a couple of different types of laws, starting with the Constitution. The Constitution is the ruling force of pretty much a country. And a common misconception is that citizens' rights comes from Constitution. It Well, a part of it does, but the document, or rather the Constitution, is actually geared towards more of a formal list of limitations set upon could be the federal, state, as well as the local level along the three different branches. That's the executive, the judicial, and the congressional. We also have the statutory law, which is a law that is also made by the government, such as a legislative body, could be the Congress or the House as well. And it is usually not greater than the Constitution, meaning it doesn't hold higher power than the Constitution. On the other hand, we have civil law. This applies to dispute between private individuals, so two different private citizens. Like, an issue between two private citizens is covered under civil law. And one major area of civil law is the tort law, and that is the law that determine whether or not an individual should be held legally accountable for the injury of another person. In addition to tort law, there are other aspects of civil law that also involve two private individuals, could be divorce, could be family law proceedings. We also have the criminal law, which deals with instances in which an individual commits a crime against societal rules. That is, if I go ahead and commit a crime that is, or rather, if I go out ahead and do something that is against my locality or the jurisdiction of where I live, then that could fall under criminal law. Could An example of criminal law could be armed robbery, um, robbing a bank. We also have common case and precedent, which is precedents and authorities set by previous court rulings. So if there is no law in place for a certain type of, could be a crime, could be any case, if there is no law in place and the court pretty much is faced with trying to pass a verdict along the line towards that case, whatever the court sets has set precedents for future cases until a law that relates to that type of case is passed. Precedent law will always take place. There is a major difference between policy and law, which is ignorance of a policy is actually an acceptable defense. So if one doesn't know that a policy exists and they can prove that they truly do not know, they could walk away with a minor offense. Whereas ignorance of a law is inexcusable. Next, we have ethics. We're going to talk a little bit about how ethics regulate and define socially acceptable behavior. And that is within every society, could be a certain organization, could be a certain country, but every organization have what is considered a socially acceptable behavior. We also have cultural mores, which is fixed moral attitudes or customs of particular group. Education is usually the overriding factor in leveling ethical perception within a small population. So awareness and education tends to pretty much drive how a certain small population behaves. Within an organization, employees must be trained and kept aware of all the expected behaviors of an ethical employee, as well as many other information security topics. An example is as as an information security professional, you shouldn't pretty much try to break into other people's computer. There is actually a law against that. But if there were no law, then ethical behavior should stop you from doing so. There are certain ethical differences across different cultures due to differences in backgrounds and where we all come from. Cultural differences tend to create difficulty in determining what is and is not ethical. Basically, two people from different backgrounds, completely exposed to different societies, coming together might have a bit of a difficulty when it comes to deciding on what is ethical and what is unethical. An example of this as it relates to technology could be software licensing, yeah, and maybe misuse of corporate resources. Along the lines of software licenses, it's actually pretty common in developing nations to for individuals to actually buy their softwares from just a second hand or rather an untrusted provider where you just walk out of the street and walk into a store and just pick up an illegal copy of a software that was downloaded illegally online and just use a keygen to crack or rather unlock or use it as a license. And we have seen a lot of these issues in developing nations where actually a lot of individuals do not know that it is unethical. One could be as a result of lack of education towards software licensing. It could also be the fact that they have no access to the original vendor or rather the original creator or licensed distributor of that software. And it results into scenarios where the only acceptable way of getting a software is spending your money to buy illegal copies. It happens a lot in developing nations. Right. Now that we understand laws, policies, ethics as it relates to information security, what are certain liabilities that falls on organizations that relates to information security? Liability is pretty much the legal obligation of an entity extending beyond criminal or contract law, including the legal obligation to make restitution. Now, restitution is the legal obligation to compensate an injured party for wrongs committed. These are some types of liabilities that definitely fall upon organizations. So, if an organization did something wrong, they are legally binded to make a certain restitution, that is compensate the individual for, could be an individual, could be a company. They have to compensate them, could be in monetary value or some way, for the wrongdoing that they committed. We have seen cases where, take the Wells Fargo case, for example, where it was alleged that they've been creating numerous accounts in their customer names without their customers' authorization. They had to pretty much compensate all the victims in some way. We have situations where there are laws in place and companies do not implement controls, privacy controls, or comply, complies with the laws in place, and something goes wrong, their customers get all affected, and they have to compensate all the customers in some way. Due care. So, due care is the legal standard requiring a prudent organization to act legally and ethically and know the consequences of their actions. Due care is pretty much doing what is right, and due diligence is knowing what is right. An organization must know what is right and acceptable behavior or regarding laws, regarding their customers, regarding the environment they live, and all of that. They must know what is right and wrong. The ability to know that is what is referred to as due diligence. Acting upon that right or wrong decision to do the right thing is called due care. Jurisdiction. Jurisdiction is court's right to hear a case if the wrong was committed in a territory or involved in its citizen. So if you are in Washington, D.C., and you commit a crime in Washington, D.C., that is the jurisdiction of that crime. However, if you are not a resident of Washington, D.C., the court might have the right to, Washington, D.C. court might have the right to summon you to D.C. for the court hearing because the crime was committed in D.C. That is all part of jurisdiction. It also is a right of a court to pretty much hear a case that involves its citizens, even if the crime didn't happen within in their soil. Sorry, on their soil. Long arm jurisdiction applies. It's the application of law to those residing outside a court's normal jurisdiction, and is usually granted when a person acts illegally within the jurisdiction and leaves. One key takeaway is that law carry the authority of a governing authority. Ethics do not. A governing authority could be the government, pretty much. So, how, as an information security professional, one should know how to manage and handle unethical and illegal behaviors. And the three general causes of unethical and illegal behaviors are usually ignorance, accidents, and intent. Ignorance can be handled by creating awareness and letting all the employees and everybody know that this is unethical and doing this is also illegal. Accidents usually happen, and there are also controls in place to minimize the risk of accidents. Intent is pretty much intent where the person committing the crime clearly knows what they're doing. We also have deterrence. That's the best method for preventing an illegal or unethical activity. Some of the best method includes having laws in place, policy in place, and also implementing technical controls. We discuss what laws are. We also discuss what policies are. From chapter 2, you should be able to understand what technical controls are. And also in chapter 5, risk management, we are going to talk about implementations of technical controls. But basically, technical controls are technical implementations that stops a system, a user, or anything from acting in a certain way that it shouldn't. Laws and policies only deter if three conditions are present. So It can only apply if there is a fear of penalty, probability of being apprehended, and probability of penalty being applied. Within the US federal, state, and local level, there are certain laws in place that, and we are going to look into all, well, not all, but we are going to look into the major laws that applies to technology, information security, privacy, copyright, financial reporting, encryption, identity thefts, and also espionage. It is the responsibility of information security professionals to understand federal, state, and local laws and regulations and also ensure that organizations are in compliance with regulations. This also applies if an organization is an international organization, then the organization must comply with international laws. And if the organization operates in different jurisdictions, including different countries, different states, it is the responsibility of that organization to comply with laws of the places they operate. The United States has always been a leader in the development and implementation of information security legislation, as well as it always contributes to a more reliable business environment and a stable economy, I guess. Also, the United States has demonstrated an understanding of the importance of securing information and has specified penalties for individuals and organizations that breach laws in place. There are quite a lot of federal laws in place, and we are going to start with some of the general computer crime laws that exist within the US. First is the Computer Fraud and Abuse Act of 1986, often called CFA Act. It is the cornerstone of many computer related federal laws and enforcement efforts. We also have the Computer Security Act of 1987. It is one of the first attempts to protect federal computer systems by establishing minimum acceptable security policies. And the federal computer systems are basically just United States government federal computer systems. There is also the National Information Infrastructure Protection Act of 1996. This law modified several sections of the previous act and increased penalties for selected crimes. Severity of the penalties was judged on the value of the information and the purposes. For purpose of pretty much commercial advantage, private financial gain, and also to avoid criminal acts. We also have the USA Patriot Act of 2001 that was enacted after September 11, and it is meant to provide law enforcement agencies with broader latitude in order to combat terrorism related activities. It is the law that gave pretty much access to law enforcement to enact wiretapping and all those monitoring and monitoring related activities done by law enforcement agencies for intelligence and information gathering. We also have the USA Patriot, that's the Improvement and Reauthorization Act. That's just to reauthorize the USA Patriot Act of 2011. In 2015, the USA Patriot Act expired because it failed to pass Congress. However, the USA, I believe it was in June 1st or July 1st, it failed to pass the Congress, and the following day, USA Freedom Act was passed, and it inherited selected parts of the USA Patriot Act. We also have laws around privacy, and Privacy, it's right of individual or groups to protect themselves and personal information from unauthorized access. It is one of the hottest topic today in information security, and this is because of organizations and tools and devices' ability to aggregate data from multiple sources, which allows the creation of information database bases previously impossible. And by putting all those informations together, you are able to pretty much get a lot of information, a lot of privacy information regarding individuals, organizations, countries, and all of that. This really results into the need for lots of privacy laws in place. And lately, the number of laws addressing an individual rights to privacy has grown. We've seen how the GDPR came in and pretty much really transformed the European technology arena. Some of the laws around identity, no, some of the laws around privacy includes USA Code 47, Section 22, which pretty much provides the privacy of customer information section of the Common Carrier Regulation. We also have the Federal Privacy Act of 1974. We also have the Electronic Communication Privacy Act of 1986. These are all that of the 1986 is the law that mandates all communication mediums to have encryptions in place to ensure that people cannot tap it, but only meant for certain types of information like PIIs, that's personally identifiable information, should always be encrypted. We also have HIPAA of 1996. This is the law that protects patients' records as well as so whenever you go to the hospital, your right for your information to be protected and your diagnosis and all your medical records to be protected and not shared with other people falls under HIPAA Act of 1996. We also have the Financial Services Modernization Act or the Gramm-Leach-Bliley Act of 1999, which is more targeted toward financial industries. There is the Child Online Privacy Protection Act, COPA, which is what protects children below the age of 16, their behavior online. FAPA, it's more towards education, and this is the same law that protects students' transcripts from being shared. We also have FOIA, that is the law that requires federal agencies, Federal Information Freedom of Information Act of 1966. It is the law that warrants individuals to pretty much request information from the government agencies, so long as those informations are not national security threat. We also have laws around identity theft. Identity theft can occur when someone steals a victim's personally identifiable information. Uh, it could be social security number. It could also be name, date of birth, and by stealing the PII and possessing and when a perpetrator possesses the victim to conduct action that falls under identity theft. The Federal Trade Commission pretty much oversees efforts to foster coordination, effective prosecution of criminals, and methods to increase victims' restitution. Missed my slide. US Code 18, Section 1028, that is the fraud or related activity in connection with identification documents, authentication features, and information act, covers identity theft. FTC is the agency, pretty much is the commission that oversees all efforts related to identity theft. And we have export and espionage laws. The Economic Espionage Act of 1996 it's meant to pretty much protect state secrets. So if you work for the US government and you know certain secrets of the US government, Espionage Act is what stops one from sharing that information with other countries to ensure national security protection of the United States. We also have the Security and Freedom Through Encryption Act of 1999. It's the act that includes provisions about encryption that reinforce the right to use or sell encryption algorithm without consent for key registration. It also prohibits the federal government from requiring the use of encryption. It make it not probable cause to subject criminal activity. It also relaxed the export restriction on encryption algorithm. Before this law, it's actually a violation to carry an encryption algorithm out of the country or into the country, a certain level of encryption. If you want to know more about encryption algorithms, definitely read about cryptography or take the cryptography class. We'll cover a little bit of cryptography in the subsequent chapters. Next, we have the US copyright laws. The US Copyright Office handles pretty much everything intellectual property related, but IP was recognized as a protected asset in the United States, and then the copyright law extended into electronic formats, and with proper acknowledgement, it is permissible to include portion of works, other people works as reference only, and it has to be with some certain acknowledgement in place first. And we also have the Sarbanes-Oxley Act of 2002, and that's a law related to financial reporting. It affects the executive management of publicly traded corporations and public accounting firms. It also seeks to improve the reliability and accuracy of financial reporting and increase the accountability of corporate governance in public in publicly traded companies. Different penalties exist for non-compliance, and it ranges from fines to jail terms. Certain key US government agencies exist with different roles, and they all pertain to either information security, cybercrime, technology, or some sort of a national security. DoD is part of the executive branch, and it is the National Security and Armed Forces agency, or pretty much department, that handles everything related to national security and armed forces. We also have the CIA, and it's pretty much comprised of civilians, and it operates on foreign soil. And CIA's role responsibility is foreign intelligence gathering as well as national security intelligence gathering and processing. Department of Homeland Security, DHS, its responsibility is to protect the citizens as well as the physical and informational assets of the US. It maintains the United States Computer Emergency Readiness Team and provide mechanisms to report phishing attacks as well as malware. That is the role of the US SAT. We have the United States Secret Service. In addition to protection services for executives, legislatives, and the important people, I guess, like the president, the United States Secret Service is also responsible for safeguarding the U.S. financial infrastructure and payment system to preserve the integrity of the economy. The NSA is the cryptologic organization of the country, of the US. They do a lot of encryption algorithm and cryptographic calculations as well as mathematical calculations. NSA is responsible for signal intelligence and information assurance, as well as information assurance directorate. That's the IAD. The IAD is responsible for the protection of systems that store, process, and transmit information of high national value. Then we have the FBI. The FBI is works under the DOJ, that's the Department of Justice, and the FBI is the primary law enforcement agency of the nation. The FBI also investigates cyber crimes, any pretty much crime related, be it traditional crime or cyber crime, the FBI investigates that. Part of the FBI US Infragrad program, the FBI um, maintains an intrusion alerts, suspicious activities, and secure web and network communications. Now that we have seen pretty much laws and agencies as well as governing bodies within the US, we are going to look a little bit into the European computer security laws. Starting with the Computer Misuse Act of 1990, this is a UK law that defined three computer misuse offenses, starting with the unauthorized access to computer material, so you cannot hack or do anything like that. Pretty much no unauthorized access, as well as no unauthorized access with intent to commit or facilitate commission of further offenses, and unauthorized acts with intent to impair or with recklessness as to impairing operation of computers. There's also the Privacy and Electronic Communications, that's the EC directive, and it was passed in 2003 and focuses on protection against unwanted or harassment over the phone, email, and SMS text messages. There is the Police and Justice Act of 2006 in the UK, which is meant to update the Computer Misuse Act of 1990. It modified the penalties and created new crimes defined as the unauthorized act with intent to impair operation of computers. And of course, we have the GDPR, which is a regulation in the European Union, and it pretty much regulates data protection and privacy for all individual citizens of the European Union and European Economic Area. We also have laws, international laws, and legal governing bodies at the international level, starting with agreements, laws in place, as well as different agencies and standards that operate internationally. We have the Agreement on International Related Trade, s- Agreement on Trade Related Aspect of Intellectual Property Rights. That is just pretty much an agreement that was mandated and created by WTO, that's the World Trade Organization. Because organizations do business on the internet and the internet operates globally, it means they do business globally. And professionals must be sensitive to the laws and ethical values of many different cultures, societies, and countries because of the political complexities of different nations. And few international laws pretty much cover privacy and information security because it's really hard to enforce laws at the international level. Um, Even though these laws are really important at the international level, it's really kind of hard to enforce it at the international level. But starting with the agreement on trade-related aspect of intellectual property rights, the agreement covered five issues, which is application of basic principles of trading system and international intellectual property agreements. There is also giving adequate protection to intellectual property rights, enforcement of those rights by countries within their borders, as well as settling intellectual property disputes between World Trade Organization's members and transitional arrangements while new systems are being introduced. We also have the DMCA, that's the Digital Millennium Copyright Act. And this is just US contribution to international effort in order to reduce copyright, trademark, and privacy infringements. The DMCA prohibits circumvention of protection and countermeasures, manufacture and trafficking of devices used to circumvent such protections, altering information attached or embedded in copyright material, and it also excludes ISPs from some copyright infringements. We also have the Council of Europe Convention on Cybercrime. This is an international task force that oversees internet security functions for standardization for standardized international technology laws. The Council attempts to improve effectiveness of international investigations into breach of technology law. And the problem is it really lacks provision for enforcement because laws are extremely hard to enforce at the international level. Last, we have the PCI DSS, which offers a standard of performance for which organizations processing payment card must comply. This include Visa, MasterCard, and Amex, that's American Express. The PCI DSS focus on six areas, which are build and maintain secure networks and systems, protect the cardholder data, maintain a vulnerability management program, implement strong access control measures, regularly monitor and test networks, and also maintain information security policy. We are going to look into professional organizations. In addition to international organizations that exist, there are also professional organizations. Sometimes these professional organizations provide certifications or just require a certain membership where a company, an individual, or even a government body can become part of them, and then they provide some codes and ethics. Many professional organizations have established codes of conduct and ethics. And as you can see, we have six, actually five of them here. We have the ACM, and the website is acm.org. And they focus mainly on security professionals. We have the ISACA, we have the ISSAA, and ISC Square. ISC Square is where their certifications are really popular. They are considered one of the top tier certifications within the realm of information security. One of those certifications is the CISSP. And we also have GIAC as pretty much an international organization. Sorry, as an information security professional organization. Now that we understand the laws, what laws, policies, regulations, and how organizations and information security professional fits into all of that, this brings us to the end of chapter 3. We were able to cover laws, ethics, the different types of laws, as well as relevant US laws. And many organizations have codes of conduct, that's professional organizations. And we also see how organization increases liability if it refuses to take measures known as due care, as well as due diligence is the effort to pretty much understand what is right and wrong, and enforcing that is due care. Thank you very much, and this is the end of chapter 3.